Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about community mental health supports. Cases that should have gone to the Supreme Court of Canada, but didn't. The province of Nova Scotia kept a wait list of individuals who were looking for placement as a result of their mental health conditions in community program settings. Unfortunately, those individuals were housed in a psychiatric hospital, in a psychiatric ward, against their will, until a spot became available on the wait list. The individuals who were waiting for a spot and housed in the psychiatric unit decided to bring a lawsuit against the province of Nova Scotia alleging discrimination, and the courts ultimately agreed that they had been discriminated against when compared with individuals who were receiving income support or financial support from the province for mental health conditions that they could better manage on their own. The Supreme Court of Canada denied the opportunity to hear the province's appeal of this decision. And although obviously, in my opinion, the correct result was achieved in this case, the result that was achieved was not a final result in the sense of we don't have a determinative case from the Supreme Court of Canada on the discrimination issue between individuals who are suffering from more significant mental health issues that require support from government that includes community placement programs, and individuals who require support just in the sense of financial support from the government to deal with their mental health issues. And having these questions unanswered raises a big problem because we see that appellate courts across Canada frequently come to inconsistent conclusions, which means that without Supreme Court of Canada jurisprudence on the issue, an appellate court in a different province could essentially say that it's okay for that province to continue doing what Nova Scotia had been doing. This doesn't provide comfort to people who are in mental health units at psychiatric hospitals waiting for community-based supports, that they can rely on the state of the law in order to ensure that they're going to be protected from discrimination. And it effectively gives the provinces a kind of a right to discriminate against people on the basis of mental health cases by saying that the Supreme Court of Canada didn't see fit to intervene in the Nova Scotia decision, and as such didn't have anything really to add to the discussion, when there's a lot that could be said. To me, this case really represents one of the circumstances in which the Supreme Court of Canada should intervene, not because it wants to change a result, but because it wants to confirm a result to ensure that discrimination does not occur and does not continue to occur against people who are incapable, as a result of the situation that the government has put them in, of accessing resources in the same way that you or I could. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.